desperately in need of IT help. Thank you. The next slide is this one. Thank you.
Sorry, I couldn't make the lunch.
I don't think I'll be able
We're
trying to get do something.
I'm going to defer to you.
Hi, my name is Kelly Lipper.
Hi.
Nice to meet you.
She works, she's the expert on Comparative. And
Teacher course in English and head protection and refugees.
so if you ask any questions about Hong Kong, I'm interrupting.
No,
I have already warned.
Any question I'm going to throw at you.
Yeah, anything at all, I will be deferring.
Anyway, I was just saying that I'm sorry I couldn't make the lunch earlier. It's really nice.
You can get your revenge afterwards.
Okay. I should have allowed a bit of room. I'm sorry.
Yeah.
Oh, sorry.
How are you? Trying to grow hair.
Well, I haven't heard anything.
Yeah.
According to my
One is
Just right. For the most on time I've ever been in my life. Okay, so we'll get a start. Thank you for everybody for coming. I'm me, and it's my absolute pleasure to introduce. Do I need to do this? Hello? Okay. It's my absolute pleasure to introduce Mr. William Kerfoot, who is a mentor and my ex-boss about 10 years ago. And so he has been a lawyer at the Legal Resource Centre for over 30 years and has a wealth of experience in refugee law, which is his main area of practice. But he's also litigated in other areas, including HIV/AIDS, treatment, prisoners' rights, disabilities, and a whole host of others. It's very exciting for me that he is here. I haven't seen him for several years as well, so it was a great excuse to catch up with him. And he will be talking about South African refugee law and practice today, a subject on which he's an absolute expert. So I'm very pleased. Please help me to welcome.
Thank you very much indeed, me. Thank you very much to the department for this invitation. A couple of corrections. Far from being me's mentor, I think I learned most of my law from her. It was wonderful to be able to catch up with her again. And just very briefly, for those of you who are not familiar with the South African situation, it was a racist oligarchy for many years, in fact, since 1652, where there was segregation of races, and there was very little scope for people from the rest of Africa to come and work in South Africa, other than those from neighbouring countries such as Lesotho, where there was a rather exploitative system of migrant labour. What there was, particularly from the 60s onwards, many South Africans went into exile for political reasons and to be part of the struggle against the apartheid regime. And they were looked after and helped by African countries, neighbouring countries, and countries as far afield as Tanzania, by countries who could not really afford it, and often at great cost to themselves, because the South African security services would launch operations against the ANC and other organizations in exile, often leading to local casualties. Unfortunately, there hasn't been great reciprocity in that respect, as has been commented on by a couple of judges in refugee matters. As far as the system goes, subsequent to 1994, when we became a democracy, there's unfortunately very little scope for legal economic migration to South Africa. Unless you have critical skills, it's very difficult indeed to get a work permit. Unfortunately, given that South Africa is now the second largest economy in Africa, it has recently ceded first place to Nigeria, it means that there's a great magnetic attraction to South Africa, and there has not been anything like a proper system of granting work permits to people who are not exceptionally highly skilled, which means that a lot of people have used the Refugee Act as a means of getting to South Africa, which in turn has led to some difficulties and some abuse of the rights of migrants by officials. So since 1994, we've had a constitution which is the envy of many countries. The Bill of Rights provides the rights of, among others, equality, human dignity, right to life, right to freedom and security of person, freedom of movement and residence, health and education, and obviously the rights of children are paramount. So although some of the rights contained in the Constitution are subject to progression, they can't be implemented instantly. Those relating to children are of immediate effect, so that can be used in many cases for claiming the constitutional rights of people. Unfortunately, there's one of the legacies of apartheid is one of violence and intolerance and lack of respect for human life. We have an enormously high murder rate. We have an enormous number of casualties in armed robberies, and there is a terribly high rate of rape and abuse of women. And that, unfortunately, is magnified when it comes to foreigners asylum seekers and refugees. So the irony is we have a wonderful constitution, we have an excellent Refugees Act, but implementation, as I hope to show you, is fraught with difficulty. The non-refoulement provision is Section 2 of the Refugees Act. It says that no person may be refused entry into the Republic, expelled, extradited, or returned to any other country if that person may be subjected to persecution on the usual grounds that one may claim refugee status. I should point out that in 2007 and 2008, South Africa had the highest number of asylum seekers entering the country in the world, which has been one of the problems relating to administration and capacity on the part of the Department of Home Affairs. So, following on from the non-refoulement, we have the eligibility for refugee status, which is based not only on the United Nations Convention, but more importantly, in my view, on the old Organization of African Unity Convention. So you are entitled to refugee status if you have a well-founded fear of being persecuted by reason of race, tribe, religion, nationality, political opinion, or membership of a particular social group. And interestingly, the department has not been particularly difficult once the matter has got to a certain stage of providing asylum for transgender people, gay people, as belonging to a particular social group. And we're hoping, with the case that's on at the moment, that there will be acknowledgement that persons who would otherwise be subject to forced marriages will qualify. I think there's no doubt that they do. Then the very important, from our perspective at the moment, qualification for refugee status provision is that of 3B, which says you are entitled to refugee status if, owing to external aggression, occupation, foreign domination, and then the vital one, events seriously disrupting or disturbing public order in either a part or a whole of your country of origin, and you've been compelled to leave the place of habitual residence in order to seek refuge elsewhere. Then finally, one which creates enormous difficulties at the moment, simply because it's such a bland and non-descriptive provision, you can get refugee status if you're a dependent of a person contemplated in these two paragraphs. Now, a dependent is aged, infirm, or indigent relative, and includes spouse. One of the issues is that many people marry other foreign people in South Africa after they've only met them in South Africa. So there's been difficulty about that. It's still to be sorted out by the courts, but we've had lots of resistance about people who were not married in their home country and who may indeed have got married to someone from another country, one in South Africa. Where they have been really ridiculous has been causing trouble because of persons who were married according to customary union in their country of origin. Again, a lot of people who are married like that don't say they're married when they arrive, because they regard it as not being a formal marriage in South African terms, either civil or religious. And that again has caused hitches. Then in order to apply for asylum, you have to present yourself at a refugee reception centre, which can be a problem. Very tragically, people have had to sleep over in dangerous areas night after night to try and get access to the refugee reception offices. There's one case of a young man called Adonis Musati from Zimbabwe who actually died standing in a queue. He'd been in South Africa for quite a while. He'd been unable to get any kind of assistance, and he actually died of starvation. He died of hunger in a queue outside a refugee reception office. But if you get there, you're in quite a good position, because no matter what your claim to asylum is, whether it's founded or unfounded, the refugee reception officer has to accept an application form for you, has to see it as completed, must assist the applicant, then must refer the matter to a refugee status determination officer, where most of the problems start. There's a very important provision, section 21(4), which says that notwithstanding any law to the contrary, no proceedings may be instituted or continued against any person in respect of his or her unlawful entry into or presence within the Republic if he's or she has applied for asylum or and has not yet had an opportunity to exhaust his or her rights to so apply. So the refugee reception officer has to grant a Section 22 permit, an asylum seeker permit, to the asylum seeker, which allows you to stay in the country and until your case has been adjudicated upon, which can take several years. And we'll get to the reasons for that in a moment. Other important aspects of the Act are the establishment of the Refugee Appeal Board, which must function without any bias and must be independent and must consist of a chairperson and at least 2 other members, which sounds very nice. The first Refugee Appeal Board man, before the Act actually got promulgated, had a record of 2 successful appeals against 700 unsuccessful ones. So his independence was brought into great doubt. But fortunately, he was got rid of. However, there's been disaster after disaster with the Refugee Board. There were too few people on the board. They were not localized, so a couple of people from Pretoria would travel to the various refugee reception offices, of which at one stage there were 7, but on a fairly haphazard basis, more or less quarterly. Then the officials, the appeal board members, didn't have their contracts renewed while they had a backlog of about 70,000 cases. So all those cases have to be reheard. They're part-heard matters, or matters in which decisions haven't been written. So that happened in 2012. What has subsequently happened is a case got brought which established that to be competent, the Refugee Appeal Board had to consist of 3 members, hearing every case, not simply an entity constructed of 3 or more members. So every hearing has to be 3 people. So effectively, that's increased the backlog again. All these cases will have to be reheard, which is disastrous for the genuine refugees. Of course, it's quite useful for those whose cases might not be that strong. The other body that we have to take account of is the Standing Committee for Refugee Affairs, which also has to function without bias and be independent. Now, the extent of the initial independence of the board was that they were all employees of the Department of Home Affairs, and in one tragic case, the chairperson of the Standing Committee deposed affidavits on behalf of the Minister and Director General. So that was quite easily drawn to the court's attention, and it resulted in the Standing Committee being chaired by an independent person. The independent person was the former chairperson of the Standing Committee. He resigned from the Department of Home Affairs and got appointed as chairperson. He actually wasn't too bad. The present chairperson is a former attorney. Again, and this is off the record, he's a very nice chap, but I happen to know that for some time, at least, considerable time after his appointment, he was on a 6-monthly contract. So in order not to lose his job, obviously there was a conflict of interest as to whether he wanted to take decisions that would be unpopular with the department. I don't know what the present position is. In terms of Section 25 of the Act, which I haven't put on the screen, the Standing Committee for Refugee Affairs must review manifestly unfounded decisions by the refugee status determination officers. They have the power to invite the United Nations High Commission for Refugee Affairs to make submissions in respect of any such case. They can request the attendance of anyone who can assist them with information relevant to the case, and they can make their own investigations and request the applicant to appear before them. We'll see what happens in practice shortly. Generally, with these cases, despite the excellent framework provided by both the Constitution and the Act, there have been enormous problems with lack of capacity above all, where you have people who are not trained, who don't have the requisite IT backup, interviewing people who are flooding in. And as I mentioned, this case of poor Adonis Masati, there were lines and lines of people unable to attend, unable to be granted the permits to which they were entitled. At the outset, there was a bureaucratic obstruction. So when people got rejected, even prior to the coming into force of the Act, at which time, as I think I pointed out in my abstract, there was a little tripartite agreement cobbled together by the UNHCR, the government of Mozambique, and the government of South Africa in 1993, when there was a huge influx of Mozambicans fleeing problems in their country, which provided, it was based more or less on the UN Convention, but it was woefully lacking in that it didn't provide for reasons to be supplied to applicants, yet it gave them, I think, a ridiculously short time within which to appeal without anything to appeal on. Nevertheless, there were objections by the state in review cases that were brought, saying that if a person has no right to be in South Africa as found by an RSDO, then they have no standing to contest their decision. In South Africa, there was a nasty echo of that a few years later with the case of KK Mohammed, who blew up the United States Embassy in Tanzania, and I'll get to that in a moment. So they challenged the standing of an unsuccessful asylum seeker to seek the protection of the court, which was rejected. They sought not to give reasons. That was sorted out. And they were generally unhelpful. There's a sad echo of the old influx control departments, the so-called Department of Bantu Affairs, whereby black South Africans were not able to live or remain in urban centres unless they had particular permits, and these permits had to be renewed once a year. The same intolerance, the same hostility, the same absolute lack of sympathy towards asylum seekers has been manifested and is a continuing problem. The other big problem, non-legal problem, really is that of corruption. Because the process is so unwieldy and people are desperate to get asylum status, the temptation both on the part of the official and the applicant over many years is to make things easier. And it became really an industry, and the Department of Home Affairs has failed completely to deal with it. So they would try and implement ludicrous measures like making it impossible to access another centre's cases. So someone in Cape Town would be unable to check on a permit that had been granted in Pretoria or Durban, because they thought that if people did have national access, there would be scope for corruption. Similarly, no official above a certain level could be promoted in the area where he or she had been working previously. So you have an official who understands everything about Pretoria, wanting promotion, having to be transferred to Cape Town or Port Elizabeth. These were inadequate and ineffective measures. The other real problem was that even internal investigations were stymied or sabotaged. So an undercover investigation by the department itself got cancelled for one does not know what reason, when a substantial amount of evidence regarding corruption had been obtained. There was a senior official in Cape Town who was very difficult, very belligerent, but who had a thriving backyard industry providing recognition certificates for refugees. And instead of being put in jail, she was actually promoted and sent to Pretoria. So corruption was rife. We had an intern who was slightly shorter than and much slighter than me, who went down to Home Affairs one day to try and take an appeal for someone, and saw an official wandering around with a clipboard collecting money. So she pointed that out to another official, and the first one made a nasty gesture to her. So we thought something desperate had to be done, and we got hold of the Cape Times newspaper, where the news editor fortunately had an intern who had grown up on the border with Zimbabwe and who spoke fluent Shona. So he went and posed as an asylum seeker from Zimbabwe, and on payment of 800 Rand, he duly got his permit within 3 weeks. So this, of course, went onto the front page of the newspapers, and for really approximately a week, things were run properly at the Department of Home Affairs in Cape Town, but they soon lapsed into what is alleged to be corruption that is now rife. I mentioned earlier the issue of marriages. There was considerable problem with refugees and asylum seekers who married South Africans. In the first place, Home Affairs, quite understandably, considers any marriage by a foreigner with a South African to be a marriage of convenience, and in many instances they're right. It was a terrible spate of divorces in Gauteng once people had passed the 3-year limit, which was then a 2-year limit, within which you couldn't get status unless the union had come to an end by natural causes. So they're right to be concerned, but there was a real problem with asylum seekers and refugees because the department insisted on their providing passports. Now, one of the things usually affecting refugees is you don't have a passport when you flee your country with bullet wounds in your back. So that was an issue, as well as the fact that they required asylum seekers and refugees to abandon their claims to asylum in order to apply for residence on the basis of their marriage to a South African. But the courts put that right in both respects. As far as the Hughes issue is concerned, there's a case of Tafira, which is similar to a case I'll deal with in the Western Cape shortly, where because of the inordinate delays in interviews and processing asylum seeker applications, they tried to use a system of pre-screening. So they call an applicant into an office, say where you're from, and then say, you know, you're from a country which doesn't produce refugees, so push off. Or they would provide a person with a tiny slip of paper with an appointment up to 6 months later, which was of no legal significance or assistance at all. So the court strongly deprecated that, and that system got abandoned. Now we get on to the refugee status determination officers, who are the reason I'm the nervous wreck I am. They really are appallingly badly trained. They don't even follow the easy prescripts of the United Nations High Commission for Refugees guidelines, which are really useful, really good, and really easy to follow. So the standard rejection by a refugee status determination officer was the burden of proof. And they quote the first sentence of paragraph 196 of the UNHCR guidelines, which says that the onus is on the person making the claim, which is fairly straightforward. They don't. So that was used as a basis for rejecting applications by asylum seekers. And they failed to point out the balance of the paragraph, which goes to great lengths effectively to establish that the issue is a real risk and a reasonable possibility of persecution, which was reiterated in an excellent case in Gauteng of Tantouche versus the Minister of Home Affairs. So they would have selective quotes not only from the guidelines but also from any country of origin information. The problem with that not only was it the selection, the selective nature of the information they would use, but the fact that it was never, and still is not, put to the applicant. So the basic administrative tenet of administrative justice, that you are given the case you are faced with, was completely ignored or breached. So a person would say, I come from northeastern Democratic Republic of Congo, there's a civil war on, people are getting hacked to bits, and I'm frightened. And the refugee status determination officer would write all this down, then go away and write his decision and saying, I've just checked up, and in fact the northern Congo is an earthly paradise, and on those grounds you have to go. And that information is never put to the person to respond to. And it's the basis for most reviews of decisions by the RSDOs. There's several, I mean, an enormous amount of ridiculous examples. I'll restrict myself to a couple. The one is that people from Somalia are told that you say you ran away because your father got blown up by a bomb 20 yards from your home and you were frightened. You've lived there until the age of 23. There's no reason for you not to continue to live there. That's a genuine, more than one example of that. We have a crazy example where a woman stated she was raped in the Democratic Republic of Congo. She came from somewhere in Kivu, I think from Goma, and she was told that a road, this was a 2013 decision, a road was built, I think, by a German company in 2006, and only 30 kilometers remained to be completed between your town and Kisangani, which means that security is better, which means that you no longer have a well-founded fear of persecution or harm. A man from Burundi, the RSDO said you left your country because of politics and your father was killed by the FNL. You failed to show you were subject to persecution. And this is another major problem that many refugee status determination officers look at the matter as actual persecution rather than a well-founded fear of persecution. So really the odds are terribly heavily stacked against asylum seekers. Again, a fellow from the DRC who, this is quite a popular claim from the DRC, I'm starting to get a bit skeptical about it. People say they were election monitors and they criticized behavior on the part of election officials, or they thought there was something dodgy about a particular constituency office or a polling booth, and then they are in danger. But I believe everyone who says anything about being reasons for being an applicant. So this man said he was an election observer. There was violence after the results. He organized demonstrations against what was happening. Soldiers came to his place and killed his family, and the RSDO decided that he had failed to show persecution. A journalist in Bukavu was raped in front of her family. She was told by the soldiers who raped her that it was her last warning, and again the decision by the RSDO was that she had failed to show persecution. This is my first attempt at PowerPointing, so please bear with me. The problems where asylum seekers are subjected to this kind of injustice is that they are likely to be arrested at any moment. They can't get work. The Department of Labour has issued blood-curdling threats about any employer being found to employ people who aren't legal in South Africa. It's very difficult to get access to services. It's very difficult to get to a hospital if you don't have a valid permit, although the Constitution provides clearly that you have a right to seek health services. And any kind of social benefit is hard, if not impossible, to get hold of. The other issue is that is that it leads to corruption in society in general. So as asylum seekers, who are usually dynamic people, it's the reason they get to a safe country, they do any kind of work, and many of them do 3 jobs in a day. One of the unpopular industries for South Africans is the security industry. We have, because sadly the police force in South Africa has failed to be transformed properly since apartheid days, it has not, unfortunately, become the protector of society. There are terrible statistics about police brutality. In fact, last year, possibly the year before, more people were killed by the police than in any one year under apartheid. So things are bad as far as that's concerned. The corollary to that is that there's an enormous private security industry. There are security guards in practically every suburb and all over towns. Yet, unless the private security industry regulations have provided that you have to be a permanent resident or a citizen of South Africa in order to be registered as a security guard. There's an exception to that. It's not a blanket prohibition. You can get registered provided you go through a fairly tedious process, which is not often successful. So what has happened is that employers knowingly employ persons either who have only an asylum seeker permit or who don't have anything, and help them acquire fraudulent documents. That then manifests itself the moment the poor security guard says, you're underpaying me, or I've been unfairly treated. He or she then gets reported by the employer to the authorities. There's one excellent arbitration result where the arbitrator, just on an unfair dismissal, accepted that the evidence showed quite clearly that the employer had been complicit in this. But it does leave people very vulnerable to abuse, not only in the security industry but everywhere. Seasonal workers in agriculture are exploited because they have got no security and are unable to protest against their conditions of employment. And they're subject to a further problem, which is that many rural South Africans resent their employment, and so there have been terrible attacks on settlements in farming areas against foreign labourers who really have no legal purchase to get assistance over the attacks. Okay, so far it's been mainly incapacity with a little bit of corruption. Now we get on to the more direct and active attacks on asylum seekers and refugees. By the way, just as a covering statement, there's often a failure to implement court decisions in favour of refugees, which then mean repeated returns to court. Fortunately, the courts have got a little impatient now, and they are more willing to provide costs against individual officials who are flouting the law or resisting actions unreasonably. And this was manifested recently in an excellent case regarding a negligence on the part of a hospital, but it's certainly applicable to issues in home affairs. The one problem, again, of having a democratic constitution is that the old provisions relating to contempt of court have been watered down a lot. So it's extremely difficult to have an official convicted of contempt of court at the moment. But the de bonis propriis provisions for costs against an individual, we hope will make things easier, where Home Affairs attempt to deny the undeniable, such as in the case of Abdi, where a Somali had tried to travel while still an asylum seeker, and his friend actually had status. They went to Namibia, where they were arrested and returned to South Africa, and South African Home Affairs, in wanting to deport them to the delights of Mogadishu, denied that they were on the South African system. So that sort of thing should really be, should embarrass the department. It doesn't. But I think civil society will have to get much tougher on that. So over the years, various obstructions have been raised. There's been a refusal to renew or process permits obtained in other centres. Without any bias on my part, Cape Town's quite a nice place to live. So a lot of asylum seekers get their permits in rougher areas such as Pretoria or Musina, and move to Cape Town, where they have family structures or where they think they're more likely to be able to get work. And periodically over the years, Home Affairs have refused to renew or process permits obtained in other areas. So there are 3 or 4 cases between 2001 and 2012 where orders were obtained by consent with the agreement of Home Affairs to say that they will process these cases even though they were obtained in other centres. This has now come to a full stop because of the closure of the refugee centres to newcomers, which I will deal with shortly. On the inertia issue, the case of Kaliko became a structural interdict to compel the department to provide greater capacity in order to be able to service the number of asylum seekers wanting assistance on a daily basis. The origin of the case was that the chief immigration officer in Cape Town decided to do a little private reduction of the burden on the department, and he went and arrested people who were actually in the building applying for asylum. But the judge said that the department should come back and report within 6 months on the necessary steps to alleviate the problem. And that case dragged over for some years, with the department at least increasing its officials from 9 to 52, and providing a proper technical support eventually. However, the situation was still not completely resolved, and but the department came up with the idea that a great proportion of asylum seekers, which was true, came from Zimbabwe, and a Zimbabwean dispensation had finally been agreed on, which would mean that you could get a work permit for 2 years if you were a Zimbabwean. The judge accordingly discharged the structural interdict, and of course nothing got done for quite a while, but the Zimbabwean dispensation did come into effect. It was one of the very effective interventions and projects by the Department of Home Affairs. It's really unfortunate that it couldn't be translated into other areas, and that did in fact reduce the burden. Then someone got a bright idea in the early 2000s that one of the ways they could check asylum seekers was to prevent them from working for the first 6 months of their presence in South Africa. Now, you couldn't get a better system to provide for crooks coming to South Africa who would be able to make financial arrangements to survive for 6 months and to prejudice genuine asylum seekers who arrived with nothing. Because asylum seekers are free to travel, work and study in the country, there obviously is no financial support for them coming from the government. So this was a disaster. But Mrs. Wachanuka challenged that, and in really ringing terms, the Supreme Court of Appeal said that human dignity knows no nationality, and it was completely unlawful. And much to the resentment of Home Affairs, that has been the situation ever since, although it is now under threat because the ANC wants to restrict the rights of foreigners, and in particular asylum seekers, to manage or own businesses. So these little spaza shops which sell, and particularly when Somali people are concerned, sell vital household items like bread and cooking oil and milk at terrific prices because they cooperate in getting discounts. And they provide South Africans with income because most of them operate from a South African home to which they have to pay rent. But those are now in danger. One of the other manifestations of this attitude is the so-called asylum transit permits. In terms of the Immigration Act, Section 23 provides that, or it now provides you only have 5 days. Until recently, it provided that if you wanted to seek asylum, you had to apply at the port of entry for an asylum transit visa, which would enable you to get to a refugee reception office within 14 days. The department, again, many people don't come in through port of entry for obvious reasons. Many couldn't get assistance within 14 days for the reasons I've given, incapacity. So it's effectively been a dead letter anyway. But it is trumped by the provisions I showed you at the outset of Section 21 and Section 22 of the Refugees Act. But nevertheless, there was an attempt a couple of years ago to refuse assistance to people claiming asylum if they didn't have an asylum transit permit. Fortunately, that got stopped. Then a subsequent event 2 years ago was that, and again, this was a denial, denying the undeniable. The department denied that it was a directive. Several different immigration officials said that it was now a standing order. Persons who were unsuccessful, who'd got a final rejection, either from the Refugee Appeal Board or from the Standing Committee for Refugee Affairs, would arrive to renew their permits, all unsuspecting, after 5, 10, 15 years in the country, and be told, we're arresting you in order to deport you because the Standing Committee has rejected your claim or the Refugee Appeal Board has rejected your claim. Again, that was only a spasm. It has been stopped, but it's typical of the attitude, I'm afraid, of the department over the years. Now we get to the real crackdown. The closure of the refugee reception offices. There was an illegal closure of the Crown Mines refugee reception office near Johannesburg, which went more or less unsung. It was found to be unlawful, but nothing was done about it. Then Port Elizabeth was closed down. Then in Cape Town, they purported to close down the refugee reception office to newcomers at a time when Cape Town was the second busiest refugee reception office in the country. So it made no sense at all. There was no alternative either. there was nowhere for people to go. The Pretoria office was, or officers were completely overloaded. The Messina office was very busy. It would have been nightmarish, mean that people would be in the position they were prior to the Kiliko case. So that was attacked. The two Cape courts which dealt with it, the one on an urgent basis, the other on a final basis, said it was completely unlawful. They said it amounted to administrative action, and that administrative action had been unlawful, and that in any event it offended against the principle of legality, because there was no rational connection between the closure and what the government was trying to achieve. The Supreme Court of Appeal, and there was another issue that the Standing Committee, the chairperson of the Standing Committee hadn't been consulted, or that stakeholders hadn't been consulted. The Supreme Court of Appeal unfortunately only found that stakeholders hadn't been consulted and ordered there to be another consultation, which resulted in exactly the same result. Fortunately, in the meantime, quite recently, within the last 2 months, the Port Elizabeth case got to the Supreme Court of Appeal on a different bench, which found resoundingly in favour of reopening the Port Elizabeth RRO. That is now going to go to the Constitutional Court. Part of the impetus to xenophobia in South Africa, apart from, in addition to all these attempts to stymie the rights of asylum seekers, has been public pronouncements by government. So as far back as the 1990s, the then Minister of Home Affairs, Mangosuthu Buthelezi, was saying how there was danger to jobs, there was danger to security, etc. The Deputy Minister Sisulu wanted there to be 2 camps, imagine 2 camps, one in Kimberley, one in the northern borders, but didn't consult the Treasury, so that matter fortunately died an early death. In 2008, there was a xenophobic outburst. Again, it's the climate is created for xenophobia by official recalcitrance, by public statements. There was police were interviewed there was a substantial poll amongst police in Gauteng which showed that 80% of the police thought that foreigners were criminals. The attacks on spaza shops for various reasons have shown, in fact, that the police show foreigners, migrants, as being an underclass and fuel the resentment of businesses, small businesses, against them. There's a peace and stability document, a more ironic title couldn't be found, a discussion document by the ANC a couple of years ago, which again goes for the security option that people should only be in the northern borders, where obviously the threat of refoulement is greater, and they shouldn't be allowed to run businesses. The Parliamentary Portfolio Committee, which is meant to oversee the department, is effectively a lapdog, although it consists also of opposition members. And the classic thing in the as far as an opposition member on immigration issues is concerned, was that involving Mrs. Tsebe and Pala, who were nasty people. They were not genuine refugees. They murdered their spouses in Botswana and fled to South Africa. Botswana then asked for their extradition, and South Africa properly replied, given the disgusting behavior it had shown in the KK Mohammed case, where it effectively allowed Mr. Mohammed to be kidnapped by the feds and taken back to the States, where he might have been executed. And the Constitutional Court came down firmly on the basis that that was completely illegal. Nevertheless, so in Pale and Sepe's case, the Department of Justice said, right, we want an undertaking to execute these bad guys. Botswana refused to provide the undertaking. The Department of Home Affairs then decided it would extradite them anyway. So we have to go through the whole process again to court to stop their deportation, which was clearly completely unlawful. During a parliamentary portfolio committee meeting, one of the members of the opposition railed against the decision, saying that he couldn't believe it. He didn't know about the decision anyway, but he said, how can South Africa do this to a sovereign country, Botswana? So that is the level at which the Parliamentary Portfolio Committee operates. Another aspect is that someone was very offended because some poor shopkeeper who was probably being ripped off had asked that he retain the identity document of the buyer pending full payment. My colleague Chris Waters has recently described the mindset of Home Affairs as being that of gatekeepers keeping out the hordes of foreigners in South Africa, which hasn't happened. We've got a fairly low percentage of people. The numbers are exaggerated. The senior DHA official said to him, you want these people to come here and pick South Africa clean. Then, with the latest outburst of xenophobic violence, subsequent to it, and it was, by the way, fueled by King Goodwill Zwelithini of KwaZulu-Natal, who said that foreigners should go back to where they came from, Operation Fila, which sort of means clear up, has been launched. Now, allegedly to crack down on crime, to stop xenophobia, to get rid of undocumented foreigners. So, 745 persons not in possession of valid documents were arrested. There have only been 307 arrests of the xenophobic people conducting armed attacks, the xenophobes. I think 50 people have been found to have been involved in drugs or other really purely criminal activities. So the response has again, as it was in 2008, been inadequate. And really it's a strange situation. It's a complete anomaly that a country that used to be a racist enclave and is now part of Africa is treating fellow Africans so badly and with such intolerance. And just in case you think I was exaggerating about the extent of corruption in South Africa, there's something by our greatest cartoonist. Thanks very much.
I'm going to open this up to some questions to the floor. Thank you for that really thought-provoking talk that covered a lot. I mean, for those in the audience who might not be familiar with the South African context, might be feeling a little bit overwhelmed, I suspect. But it was very rich and it covered both legislation and implementation and touched on a lot of the politics and history that shape South Africa's response to foreigners and to the refugee and the creation or the implementation of this refugee system. So I'm going to just open up to the floor and see if anyone has any questions.
Thank you very much, Mr. Kerfoot, for very comprehensive coverage of what you have in South Africa. Looks like you do have a very good constitutional framework, but in practice, it's shambles, really, and really an affront to human dignity. So my question is, what is the success rate like? So if I'm, applying for refugee status in South Africa, what's the success rate like under this system? And what is your center role in helping, refugees go through the system? Thank you.
The success rate at first instance is very poor. In fact, it's led the Minister and Director General to say repeatedly that 95% of applicants are economic migrants. What they fail, of course, to take into effect is even with economic migrants, particularly with Zimbabwe, an economic migrant is often a refugee because food and support only gets dished out to people who are known supporters of Mugabe's party. But again, there is a backlog of over 100,000 appeal cases, so one hopes that quite a few of them will be granted. Similarly, with the Standing Committee for Refugee Affairs on the manifestly unfounded cases, I'm sure there'll be a better result. What used to happen, and still to an extent happens, is people from Somalia were almost automatically given asylum, which is correct, obviously. But for political reasons, largely people coming from Zimbabwe at the height of the oppression tended to be rejected. I should perhaps have said something, but I didn't have enough time, about the Legal Resources Centre. It was started in 1978-79, modelled effectively on the law clinics of the United States and the assistance centres in the UK, and it's completely donor funded, and we don't take money from the government because of potential conflict of interest. And its ethos is impact litigation. So we don't help every deserving person who comes in through the door. We, in principle, only help people where there's going to be a tremendous result, either assisting a vast community, for instance, in attempts to evict people from land, or where the law will be changed and subsequently help lots of people. I'm afraid I'm a renegade or a rogue in that respect. I tend to help every asylum seeker who comes in through the door, no matter how trivial the matter. But in mitigation, I plead Mrs. Wachanuka to change the law for everyone. So our success rate in court and the success rate of Lawyers for Human Rights, the WITS Law Clinic, the UCT Law Clinic is quite high. But I think on the ground the rejection level is terrific. And unfortunately people don't always come to lawyers.
One of the things you mentioned, and we've talked about it as well, is RSD officers and the role that they play. And I feel that you're very critical of the South African RSDOs, right? And rightly so. And the alternative, usually we look to UNHCR. And I'm going to look at Kelly for this, because I know that you have some views about this, and I have some views about this. And, you know, who do we want to do RSDO, right? Because we know that UNHCR at the field level also has some problems. Right? And Hong Kong has just switched from a UNHCR system to a government system, which so far has produced 3 or 4 results, I think we were talking about earlier, after a year of it being in implementation. I have no idea what the backlog is, so if Kelly can help.
I actually don't have the current number. Someone else might.
So UNHCR produces these guidelines, which you rightly say is very clear and very sort of set out kind of the considerations, fairly fair considerations for how to determine status, and this is one of the first hurdles, right? And so, what are your thoughts about how to, both within UNHCR and out of UNHCR, within national systems, how to really get these guidelines properly implemented, particularly when we know that there are problems within UNHCR anyway. So it's because I think we always look to these two, which one's better, and I think there is some advantages in having a national system that has judicial review potential, which South Africa definitely does, right? And the judiciary is very active, versus an administrative UNHCR system which is not open to appeal and review.
I'll leave it to Kelly to talk about the UNHCR, but as far as South Africa is concerned, there just has to be an appreciation, which there really isn't. And again, kind of regarded as a past system. The influx control thing, RSDOs don't appreciate that they effectively have the power of life and death over asylum seekers. And you can't have people who don't understand English, who don't understand that there might be difficulties with interpretation, who are males, who don't understand that women don't actually like saying that they've been raped to a man. Or, if they do, have it treated as a trivial issue. So training, first of all, a decent qualification, and then proper training. We know that a member of the UNHCR is shortly to be in South Africa after many years to try and teach people about country of origin information. So who knows, there might be an improvement, but basically there should really be a proper qualification, not only an academic qualification, but I think an on-the-job test to ensure there is knowledge of and appreciation of the UNHCR guidelines at the very least by an RSDO, and an understanding that any adverse information the RSDO is going to rely on has to be put to the applicant. The other problem in South Africa with, as was pointed out by Ronnie Ammett in a couple of wonderful articles, is that there's a kind of and this again, it trivializes the lives of asylum seekers. She says that there is a quota system whereby RSDOs are expected to provide 10 decisions a day. You just can't do that and do justice in terms of proper eliciting of information.
But that quota system exists within the UNHCR system as well as an internal performance measure, actually. So I don't.
Well,
what
then
do
it has to be
I mean,
discontinued.
I mean, your point about implementation is true for the UNHCR just as much as it is for government. Yeah. And I mean, some of the issues you were talking about, the lack of reasons, lack of access to legal representation, were true when UNHCR was doing RSD in Hong Kong. Yeah. The big difference is the UNHCR procedures couldn't be challenged, that me just mentioned, and also lack of capacity and lack of resources. So the Hong Kong government has a lot more resources than the UNHCR had. But the success rate is quite different. The UNHCR success rate was low in terms of its global operations in Hong Kong, but it was much higher, I think, than the success rate that we've seen so far under the new system.
I have a question about, I guess, like the administrative process and why the appeals process remains under the administrations of the Refugee Appeals Board and the Standing Committee. In cases that I've litigated in the U.S. on refugee rights, even though the initial determination was by an RSDO, it gets bumped to an immigration judge, and then appeals then goes to the circuit court. So even if the initial determination by someone was not skilled, you always have the opportunity to have your day in court. So why was there, I mean, can you talk a little bit about why there isn't this opportunity until the Constitutional Court comes in?
Not the Constitutional Court, the High Court.
The High Court.
And then theoretically it goes to the Supreme Court of Appeal and then may go on to the Constitutional Court. Yes, South Africa has always, and again, as I say, there are these anomalies post-apartheid. There's still these strange attitudes. South Africa, possibly for budgetary reasons, not entirely for budgetary reasons, some for substantive reasons, has always been against specialist courts. Even with Labour, it took many years for there to be a Labour court, and I think it was only because there was a very dynamic person who was advising the minister on the Labour Relations Act, which came into effect after 1994, that it even happened. So I think to an extent they don't want a specialist court for there to be immigration judges, which is the problem, perhaps. Although the High Courts, again, there have been High Court judges who have said terrible things. There's a case, Asumo, I think it is, or Abdi, where a judge just went berserk, saying how people come into South Africa. He sounded like someone on the street, pinching jobs and telling lies and coming from as far afield as Bangladesh and so on. But they do get corrected then at the Supreme Court of Appeal level or the Constitutional Court level. But again, to show this mindset, one of the cleverest judges in Cape Town, in the first round of KK Mohammed, clearly showing an ignorance of international instruments and so on, said, is South Africa to become a haven for terrorists and criminals? Simply because we should have asked for an undertaking by the United States that they wouldn't execute KK Mohammed. But you're right, that unfortunately, especially where a matter is on paper rather than an actual trial, you have trouble rehabilitating a bad decision at a lower level. So even though one of the former Refugee Appeal Board officials said his approach was completely de novo, which in itself is a bit of a problem, you can't cure in every instance a bad decision where evidence hasn't been forthcoming simply by going to a higher court. So I think probably your suggestion is, or your implication is a good one, that one should have a specialist court at a lower level. Don't look so skeptical.
But one of the things you said was that because there are no basically visa regime for low skilled workers, there's no work permit regime other than the Zimbabwe dispensation. In many ways, the refugee or the asylum seeker route is the only way that people can come into South Africa, right? And so what you have then is clearly a mixed population. There's an irregular migration, and you have to then somehow sort out the genuine asylum seekers versus people who are pure economic migrants, because of course there are overlaps, like you mentioned. So why doesn't South Africa just set up a migration regime that governs that kind of work, and therefore, you can then strengthen essentially the refugee regime separately? And I mean, I'm assuming the answer to this will be quite political, but I was wondering if you can sort of expand on that.
No, I mean, there's no answer to that. It is the solution. And to do him credit, the head of the UNHCR, who was a former Prime Minister of Portugal, his name escapes me for a moment, it might be Gutierrez, something like that. He came to South Africa several years ago and repeatedly, not only to the faithful or the converted, repeatedly said to the then President Mbeki and to the then Minister of Home Affairs that they need to wake up to the fact that internationally there are mixed flows and they must deal with that. They didn't for ages, and at the time it would have saved face both for South Africa and for Zimbabwe by enabling Zimbabweans to come to South Africa without without showing that it was a repressive and dreadful regime. But they only woke up to that several years later, after the 2008 xenophobia. And then, as I say, it was very effectively done. They produced officials and new officers out of a hat, and the only problems were on the Zimbabwe side, because one of the prerequisites was a Zimbabwean passport, which was then very hard to get and took a long time. But it seems to be a purely political issue. Now, I raised it with a senior member of the ANC who happens to be my national director, and she said, and she came out with an answer that, yeah, that's okay in principle, but they were worried about people who were already illegally in South Africa, which didn't seem to make much sense to me. The minister that Dr. Gutierrez spoke to, apparently, according to her special advisor, was desperately in favor of granting asylum seekers some sort of amnesty, that had been in the country for X years, then you can get permanent residence provided you haven't disgraced yourself. But she said that in itself would be political suicide. I think it would be political suicide, or I don't think it would be political suicide, but government thinks they would lose votes and contribute to unrest if that happened. And an illustration of that, combined with other reasons, is the situation of Angolans in South Africa. Now, as you know, there was a long and horrible war in Angola, and unfortunately the apartheid government supported one faction, UNITA, against the MPLA, which has been in government ever since independence of Angola. So there was quite a large influx of Angolans who were granted refugee status. Now, they've been here for 15, 20 years, but courtesy of the UNHCR and the South African government, a cessation has been implemented. So people who've been contributing really well to the South African economy have found themselves now getting a little, it's not even as good as the Zimbabwean one, a 2-year deal where they found it easier to get, they had relaxed conditions relating to work permits. So if you're working as a checkout clerk in a supermarket, you can get your 2 years, or if you're studying or whatever. But there's a mean-spiritedness about it, because they have really become integrated in South Africa. And this is another of my bugbears. I think it's Section 34 of the Convention, which says that host countries must assist refugees with integration. And quite the opposite is happening in this respect. Children have been born in South Africa. Once they turn 18, they can become citizens, which is nice, but it isn't applicable to many of the Angolans. But there's a mean-spiritedness about it, because most of them were UNITA supporters, which was supported by the apartheid regime and is unforgivable. And again, there are only 15,000 recognized Angolan refugees in South Africa, and they're long-term refugees. They should have been granted permanent residence. They haven't been. And I think that's, you know, a small element of malice and a large element of political concern, which there shouldn't be. I mean, the ANC's securely in government.
Okay, I think if there's no more questions, I'm just going to thank Lillian for the talk, and thank you for being here, and thank you everybody.
Did you? Oh, wonderful.
And even if they get
Are you there?
some kind of
And he said he was in court on his 90th birthday.
He's so dedicated to human rights.
Oh, okay. He's in practice now.
Yes. I was hello. Hi, sorry. No. It's fine. He's happy to give advice. It's very quick. Very quick. No problem. I'll see you. Bye.
So your business is
United.
how are you?
Hi.
Yeah, thank you so much.
I mean, I've got my area. Yeah.
Are you doing the global?
I'm like the approach. Sharp contradiction to Australia.
Oh, yeah. You're kind of a very No, that's South. I think that's something that works before they get to Berlin. It's there are like towns-specific websites and somewhere. I was one of those persons that intended to go and make sure that they were. Until then, I didn't go back when my family, the Prime Minister. I might go back for a little bit. We'll take the time. Yeah, in August. So I actually got them. Yeah, thank you. How about you? No, I quit quite a while ago. But I don't know how. Had the Hazara.
Oh my God.
That was
amazing.
there's a conference. But obviously, helping out that. In June. And I'll be back in. Okay, that's it. Thank you.
What's your name?
So I'm sort of helping out with the student resolution.
Oh, wonderful. That's the way to go.
Dialogue.
Only that contribution
Okay. Bye.
serious internationally.
I'm very curious.
Most of the wars we do
That's right,
I'm a complete devotee of alternative careers, and it's just ridiculous that it doesn't get implemented more. And in South Africa, there's a huge scope for community issues, and issues where there's terrible violence in the taxi industry because of competing taxi firms. That sort of thing. All that kind of thing should probably be introduced, sorted out by introducing a proper system of mediation. You know that Felicia Kentridge started the resources center, his wife.
Yes. She was very, I sort of had dinner with them in London.
They probably got like
she was very involved with women's issues and things like that. That's amazing. And then one of the sons is an artist. That's right. So in fact, it's really important. When I was working in Pakistan,
listen to Desert Island Discs. Desert Island.
They get a lot of
focus on Desert Island Discs about a year ago. It's a charming interview. He's just
Good job.
so nice.
Coming.
Oh, it's such a wonderful guy.
Where are you off to?
Goes outdoors, work morning, and he's really
You are? What are you doing now?
because I'm from Malaysia. I used to
I could bring things in.
under the Internal Security Act. Indefinite detention.
What are you doing now?
Before I came to Hong Kong to work in prosecution here, I prosecuted complex commercial crime and corruption for 8 years. So corruption is
I need to go to my office very
very
briefly to buy
with Sydney because
you know about it, so it's okay.
So I was the one who tried that opportunity.
No.
I sort of came back to a project for the Hong Kong government.
And then I thought we can just go
mediation in the courts in Hong Kong. So it's back for this. one
go eat
contract.
for coffee.
So, between Hong Kong and New
Maybe
Zealand,
actually
try to
Refuge
promote
call
the
it
use of,
like
constitution, more dialogue,
I had
talking, to how people can work together. So in New Zealand, I implemented mediation to resolve human rights disputes. So instead of a investigation model where they investigate and you are right, you're wrong, whatever.
Well, we
they
did
post
only-
mediation. So we just
The
mediate whatever the dispute is.
right?
And I think now it's more than 10 years. It's really wonderful. People to talk to each other a bit more, and people are a lot happier with the situation about.
Sorry, did I say that with the wrong thing?
Very white. There's a lot of
Yeah.
things we need to put on the table, and because it's confidential. That's the best thing.
A friend of
So
mine
I drafted the mediation law for Hong Kong.
Fantastic.
Yeah. So we're trying to do it a little bit.
Such a great achievement.
Oh no. It's one of those things that I feel is really important. I think to get more dialogue going.
And then we just try.
So in Hong Kong now we
Is it
have
Irish?